go counterclockwise. You're next.
Hi, Marion Becky. I'm here with ICANN of Lehigh Valley and as an officer and board member of Empowered Birth, a local advocacy group in eastern Pennsylvania, and also as a traumatic cesarean survivor. And my question was this. I noticed that we were talking about malpractice premiums, and I wonder what effect would have if women started suing for unnecessary cesareans, and if your recommendation, if you feel that you would recommend stricter ramifications or consequences for the overuse of cesarean as a CYA procedure. Cover your.
Can you repeat the last part of what you said again about the overuse?
Would you recommend stricter ramifications or consequences for the overuse of cesarean as a CYA procedure? Cover your bleed procedure.
No, I understand. Well, I think I already alluded to that when I addressed cesarean section rates in South Florida as high as 50%. There's just no way that we can justify that if we're looking at best outcomes for mothers and babies. I think, as unfortunate as I think it is that we will not have patients sign a consent that's binding that they're not going to sue their doctors, I also think that the answer here is not for patients to sue their doctors, because that's not going to happen.
Upstairs.
Yes, regarding non-medical issues bearing on this discussion, would it be appropriate for all MDs, all OBs, to disclose to all of their patients the non-medical issues that are influencing their recommendations? For instance, the fear of malpractice lawsuits, the cost of malpractice insurance. These are things that the average consumer needs to be aware of in order to understand whether the recommendation is in fact in the patient's best interest versus the doctor's best interest.
I'm not sure. I really don't have much comment on that. I'm not sure what you're asking me. Are you asking me that do I believe that all obstetricians or all healthcare providers should sit down and tell a patient, we're going to choose option A versus option B because I don't want to get sued?
No, I'm saying that all doctors should share with their patients that these are the pressures on the medical community, and as such, you, the consumer, need to be aware that this either consciously or unconsciously is going to affect my recommendation to you.
That's one of the intents of the report.
Okay.
Will be covered.
Dr. Cunningham is saying that is one of the, hopefully, focuses of that's going to come out of the report.
Okay, let's go over here. You've been there a bit.
Hi, my name is Denise Wharton. I'm from North Central Bronx Hospital. I'm a midwife where we have the lowest C-section rate in New York State. Very proud of that. A quick question with as far as fetal monitoring goes. I see the recommendation is for continuous fetal monitoring, but I was wondering about if there was any recommendation or suggestion that internal fetal monitoring was required for patients undergoing a trial of labor.
I just want to make sure I understood that correctly. You asked whether you have to put on a scalp electrode?
And or IUPC?
I would say absolutely not. And in fact, when I was in training, it was well accepted that the external monitor did not generate as accurate information as the internal monitor because the external monitor averaged. If you have a patient and you're able to have no mechanical difficulty obtaining the quality of the tracing from an external monitor as far as fetal well-being assessment is just as reliable as an IFE. So you do not need to place an IFE or an IUPC in order to have a VBAC.
If I heard Dr. Bujo correctly, the three societies recommend electronic fetal monitoring, not internal.
Electronic, yes.
So continuous monitoring, the choice of internal, I presume, would be operator dependent, right?
Yes.
And a quick follow-up, do you see that the change into the nomenclature of tracings into Category 1, Category 2, Category 3, making any difference in the numbers of cesarean sections being done for unreassuring fetal status?
I think time will tell, but the response I would have to that is if you were going to look at your own institution from a quality management perspective, any institution, if you're doing more than 2 to 3% of your deliveries by cesarean section for fetal heart rate concerns, you're way over reading the fetal heart rate monitor. So that's a very simple thing to do in your own institution. If anyone's practicing in an institution where 10 or 12% of patients are being delivered by cesarean section because of fetal heart rate concerns, they're way over-interpreting those squiggles.
Thank you very much.
Okay, let's go back down here.
Thank you. I'm Jen Reedy, and I'm from Empowered Birth in Eastern Pennsylvania. I'm a childbirth educator and doula as well. I'd like to agree with you, Dr. Sokol, that the cost of the claim is not the malpractice issue with the doctors, whether it's $250,000 or $35 million. They're looking at loss of their practice. But I disagree that we don't need reform on that. I think that part of the issue is that the doctors think that they're going to be sued at a higher frequency than they actually do, and I've actually read that on the ACOG website, that their perception of the frequency of being sued is higher than the reality. And I wonder if the secrecy of malpractice lawsuits goes into that the doctors just don't know how many there are. And I wonder if we could have openness on that. I also have read about a hospital system in the Midwest that instituted an I'm Sorry campaign, where across the board in all practices, if doctors felt they had committed something that might be malpractice, they apologized to the patient, and they saw their malpractice claims drop significantly. So I think that perhaps we need to look at that. And as a final comment, you commented that hospitals are concerned with transparency and they want to be transparent. I would disagree with that, at least in my area. We have 5 hospitals serving our area that deliver about 8,000 births a year, and I called every one of them up looking for their C-section and VBAC statistics, and I was not able to get that data from any of the hospitals. Now, I can get it from the State Department of Health, but I actually was told by at least 2 of the hospitals that they did not think that they were allowed to release that data, and one nurse did estimate what her cesarean rate was at her hospital, and it was off by 10% from what the State Department of Health had released for 3 years prior.
Well, Teresa, you threw out a lot of things. I'd like to stand at the microphone because I want to make sure I don't forget particularly the first ones. I think, first of all, as I told you, I'm not a hospital administrator, so I can only come from the perspective I have as a physician with administrative responsibility. But my understanding is the future is more and more transparency. The consumer website that we started at Northwestern is only within the last 6 months. So I think that may change. There's an outstanding article in just the last month's Obstetrics and Gynecology from an individual whose name is, if I remember correctly, Philip Howard, who runs an organization called The Common Good. And he looked at a number of different measures that might reduce liability cost. One was this apology, which, at least in his opinion, wasn't the best. The best, according to him, would be if we actually had health courts. So, in other words, we get away from the jury system, patients can still sue, but that the case is adjudicated by judges who have experience in healthcare, just similar to divorce courts, tax courts, workers' comp courts. There are other examples, but I don't think, it doesn't really matter whether a physician gets sued 1 in 100 patients or 1 in 1,000 patients. It is on everyone's mind, and we are not going to get away from that. And I would say one other thing just about the medical legal, since I guess I have the right to answer your question. I think another huge problem is there are way too many physicians who are making way too much money being so-called experts and saying things that they would never say in their own institution under a peer review process. And we are part of the blame for this whole circumstance.
Thank you.
But I'm not sure how we're going to change that.
I have to make a very popular announcement. We have to cut off now. We're over time. I'm sorry that we didn't get to everybody. If you could put your... Well, I mean...
Look, Dan, I have one more question. I'm going to go ask him.
What? Well, I thought you were saying one more. I'm going to tell her to take it up in Paris. Shit, we've got about 8 hours work. Look, I'd love to see what $150 million apology looks like.